Yes, Priyanka, we can start 4:30. Welcome all.
Okay, can we start?
Yes, please.
Okay. Good evening, everyone. A warm welcome all. I would like to introduce myself. Myself, Priyanka Saraf, a company secretary with a 10 plus year of experience in a company law and FEMA Act. I have worked on compliances, regulatory filings, and secretarial audit. My journey with the Shreyas has been great learning experience, and I truly appreciate the support from the Shreyas team. Now let's move on today discussion incorporation of companies and documentation. Basically, in my professional, I have experienced that every incorporation is a process come with challenges. Sometimes it may be a one day job or a half day job. To truly understand what is this subject is, let's begin with the topic. Before we begin, let me ask with you, how many of you have involved in the incorporation of company? Anyone who have involved in the incorporation of company or done any kind of work related with the incorporation?
Yes.
Okay. Anyway, uh, so I discuss whenever I discuss this topic with the stakeholder, they refer me back that the East India Company, which was incorporated around 1600 December by Royal Charter under the English company law. This company played a crucial role in shaping our country economic and political system. Let me tell you one of the interesting thing. Did you know that the East India Company is now owned by Indian entrepreneur Mr. Sanjeev Mehta? He acquired the majority stake in the company in 2010 as per the latest news, and approx $15 million with a vision to revive the company. Why I'm discussing this, the British era company, because there are some British era company which are still working under the Companies Act 2013. Some of the companies, I must say, Vadia Group was founded by a Parsi businessman, and this group secured contract with the British Indian company to build the ships and dock. There are several other companies like State Bank of India, RPG Group, Aditya Birla Group. This company continues in the previous and plus it has been continued in Companies Act 2013 also. Uh, so there is a disturbance back. Okay. So studying this historical incorporation give us an insight into drafting of company documents and chartered. The Companies Act 2013 govern the incorporation of private company, public company, and other types of companies. Let me tell you the differences between the private company, LLP, partnership firm, and OPC. This all the companies are governed by the Ministry of Corporate Affairs. Let's see some of the factors. Difference between the private company, LLP, partnership firm, and OPC. As per the legal status, private company is a separate entity. LLP is also treated as a separate entity. Partnership firm is not treated as a separate entity with its partners. OPC is a separate entity with its sole proprietorship. The liability under the private company is limited, under the LLP it is limited, but in the partnership firm it is unlimited. The compliances, if you check the compliances are high in private company, moderate in LLP, and in partnership firm it is low, and OPC normal compliances we have to take care of. Private company is best for starting up and growing of the business, while the LLP, most of the professional like CA firm, advocate firm, they basically incorporate an LLP. Partnership firm is an business, a small business where the two partners run their small business and earn somewhat profit. OPC is a single entrepreneurship. that is run by only one single person. So, among this all, whenever I see the MCA data on MCA data in numbers, I'm saying in numbers, whenever I see the private company, public company, limited company, always the number of data of the private company is more as compared to the other firms or other companies like private, OPC, limited liability. If you go on the MCA, you can find that data that the private limited company is more incorporated than the other companies. Now let us start with the incorporation process. A company is formed with a memorandum of association that is called as MOA, article of association that is called as AOA, which is to be submitted to the ROC in the state where the registered office is located. How many of you think that the incorporation of a company is just a filing document? Can anyone tell me? It is just a incorporation is just a filing of an documents. I must tell you, it is not only the filing of documents. We have to proceed with certain legal formalities, including fees, stamp duties, other legal formalities, draftings, and lots many legal formalities we have to comply with while filing the incorporation. So, I must say that the company by nature is an artificial legal entity and comes into existence only after its registration. The legal framework set under the Companies Act ensuring the company with all the documentation and procedure requirement. Upon successful verification, the ROC, that is a registrar of company, issue a certificate of incorporation granting the company as a separate legal entity status. What happened basically when we approaches with the client in my professional, when I approaches with the client, I look into two aspects. The first one, minimum client interaction approach. The second is in-depth consultation approach. What happened in practical life, it is basically when we a minimum client approach interaction is where the client knows what exactly he want, what he has a clear decision that he wants to go with a private company and he wants to keep such object. So in that case, what we do, we do not suggest any alternate business option to them. We go with their ideas and search the name according to their name preferability and finalize the object and apply for an application. The advantages of this is with the interaction, minimum interaction with the client is it is an speedy and efficient process. It also has an disadvantages. If it does not interact with the client, the disadvantage also arise that later on when they grow their business, they may face some issues, because at the starting, at the time of a startup, they have given us all the data and said that we are clear about this, we want to form a company with this so and so. But when their business grow, they face certain issues. So the second which we approaches to the client is in-depth consultation approach. What we do in the in-depth consultation approach, basically we uh, we guide the client in choosing the right structure. We actively discuss the business structure with the client. We analyze their future plans, whether which company will suit them, whether the private limited company, public limited company, OPC or LLP, whatever will suit them for their business. We carefully draft their object, what business they need to run, and we well plan their incorporation process with an object that their business will be for a long term. Now, my question is, how many of you think that the most common mistake entrepreneur make when choosing a business structure? What is the most common mistake the entrepreneur make? Can anyone let me know? I must tell you, most of the entrepreneur, what the business they make, they decide by their self till a short term basis. Okay, they do not decide what they just get that we want to incorporate a company with the ABC Private Limited with such and such object. They do not go with the deep discussion with us. They do not make a for future plans for with us. So later on, what they face the problem, or they does not get their name approval. So this brings to our first crucial step in incorporation. Incorporation is obtaining approval from the company name from the Register of Companies. Can a company name be identical to an can a company name be identical to an existing registered name? No, it cannot be. The two similar name cannot be approved. If already an ABC Private Limited is already an approved name, we cannot apply for ABC Private Limited once again by the another client. So the company may select any name they can select, provided it should not violate the Emblems and Name Preservation of Improper Use Act 1950. The proposed name must be identical and similar to an existing company name. I usually ask my client to give at least 4 to 5 names just to avoid the delay. What happened? They usually give one name and we apply for that. It get rejected, or it comes under the resubmission. So I usually suggest to have 4 or 5 names in their hand. So if the resubmission come or any kind of issue arise, we can give the just another name. The application for name approval is submitted to the Central Registration Center. Who operate this center registration center, which is called the CRC. This is also operated by the Ministry of Corporate Affairs. Now the question will arise: who are the CRC? Let me tell you, CRC is also a authority which work under the ROC, that is a Register of Companies. They are professional like us only. From wherever in India, if you apply a name, it will go to the CRC only. Previously, 4 5 years back, I can say, if we apply a name, when we apply a name, the authority for the approving of the name goes to the ROC in which state we have applied. That particular state ROC have rights to approve the name. But now the case is different. All the powers and authority for the approval of the name is given to an CRC. What happened? Basically, the client gave us some name, say for ABC Private Limited. Okay, we have checked the name that we can get the name easily. There is no existing company. The we check the trademark, that the similar trademark should not be there with such name. We check all the pros and cons to get that name. Still, the CRC reject our name. Why so? The CRC reject our name after checking all the things. It may be possible because we have not followed the rule 8, which says that the company name must not be identical to an existing company. The name must not constitute an offense under any law. The name should not be undesirable in the opinion of central government. The name must not be falsely imply that the company is connected to the government, central government, state government, or any local authority unless proper approval is obtained. Once we get the name approval, it is reserved for 20 days, during which the applicant must complete the incorporation process. The CRC give us the 20 days in which we have to complete the other proceeding for the incorporation of the company. However, in rule number 9A, which you can see in the screen, we can extend the name for more than 20 days also. But we have to pay the extra fees for that. The extra fees First extension 1000 rupees for additional 20 days. Like 20 days we are already getting, then another 20 days we can get by paying the fees of rupees 1000. If you pay the fees of rupees 2000, the additional 40 days you can get it. If you pay the fees of rupees 3000, the additional 60 days you can get it. But this all you have to apply before the expiry of the your days. Like if you have a 20 days in your hand, you have to apply for the extension on the 19th or the 20 of the day, not after the expiry. After the expiry you cannot go for the extension of the name. So once the name is approved, the next step is preparing of memorandum of association. Let me tell you, the preparation of memorandum of association is a crucial step in incorporation of a company. At this stage, I engage in detailed discussion with the client, understand the nature and scope of the proposed business. While modern tools like Google provide us the references for drafting the object. But think, when in 1990s, when there was no Google, how we prepare and draft the objects of the company? We discuss with the client, we go through the depth discussion with the client and draft the object according to their will. So back then, professional and client has a depth discussion to carefully accurate the company objective. Similarly, we ensure that the object are thoroughly discussed and drafted to reflect the company intent purpose. Now, let me tell you, there are certain models in which the memorandum of association is drafted. But this depends on the criteria of company, in which criteria your company falls. Like table, if your company is limited by shares, you have to adopt the format of table A. If your company is limited by guarantee without share capital, the table B you have to adopt. The company is limited by guarantee with share capital, the table C format you have to use. For unlimited companies without share capital, table D, and for unlimited companies with share capital, table E. So when you prepare the memorandum of association, you have to adopt any of the one of the model, table A, B, C, D, or E, which under which you want to proceed with the company formation. The next come, then in the memorandum, the first clause is a name clause, where you give the name of the company. Second clause is the register office clause. The register office clause, where you just mention in which state your register office is registered. The main clause come is the third clause as an object clause. Object clause means the business which you want to run, or the business which your company will be running, the proposed business which your company wants to run. The main object of the company set a core business activities. But as we all know, no business operate in isolation. The object this the main object consist with the other two object also, that is furtherance object, incidental object, and ancillary. This object the main object. The incidental object or the ancillary object gives support to the main object. For example, if you manufacturing company, if your company is a manufacturing company, its primary object is to produce the good. But you can produce the good without acquiring land, without hiring a skilled employee, without protecting your trademark or the finance. No. So this the ancillary objects support your main object. To ensure the seamless operation, a company has an power to acquire the asset and infrastructure necessary for the business growth, manage the finance, secure loan, and raise the capital as needed. Enter into a contract agreement and partnership for expansion. hire the employees, appoint consultant, and establish effective management. Protect the intellectual property right, such as the patent, trademark, and copyright. Ensure its assets and mitigate the business risk. Friends, carefully drafting of this incidental object or the supporting object is very essential. It helps your company to clear its vision and operation and to work in a flexible and in a smooth manner. A well drafted MOA can only protect your long term vision or can only protect the company or the owners of the company from the legal hindrance. So, while preparing the MOA, we should engage in the deep discussion, understanding the business, what are its long term business. Now, I ask you one question, a quick question. Do you think whatever I have said, like we have a certain object name clause, certain clauses, name clause, second comes the register office clause, the third comes the object clause. So this clause can be modified after incorporation. We can modify this clause, like for example, our object is a manufacturing company to produce the good. Now we want to go in some other business. We can modify the object, or we have to incorporate in another company. The answer is yes. We can modify the object after the incorporation, or we can modify the name after the incorporation of company, or we can shift the register office after the incorporation of the company only through a formal legal process. Now, this brings us to the liability clause. When incorporating a company, one of the most critical decisions that shape its legal liability is a liability clause in Memorandum of Association. This clause defines the extent to which the member of the company are responsible for its debts and obligation. It is not just a legal formality, it is a shield that protects the individual and business from an unforeseen financial risk. Imagine you invest in a company. Would you prefer to go for a limited liability or an unlimited liability? Anyone can. If you invest in a company, would you prefer to go with a limited liability or an unlimited liability? Correct. Most of you are saying unlimited, unlimited. Yes. There, let me tell you. So, what does this clause entail? Is establish whether the liability of a member is limited or unlimited. There are three types of liability in a company: limited by shares, unlimited company, company limited by guarantee. So let me tell you, limited by shares. In most of the cases, company opt for this structure where the shareholders are liable only up to the amount unpaid on their shares. Once fully paid, their risk is limited. No creditor or no one can demand more than what they have invested. This is a limited by shares. Limited by guarantee, this is mostly commonly adopted by the non-profit organization where they are limited up to a certain guarantee only. Guarantee means they are limited up to a certain contribution. Their personal wealth remain untouched beyond their guarantee. Unlimited liability, this unlimited liability is very rare category where the member personal asset are at risk. Nobody will like to have to go with the unlimited liability. Most of the companies are with the limited by shares or limited by guarantee. Nobody will take any kind of risk that it may later on, if the business is in difficulties, their liabilities is limited and they have to sell their own properties. Next come, why does this clause matter? Because the choice of liability directly impact the business risk, investor confidence, and financial securities. Imagine running a business where in the times of financial trouble, creditor claim claim your personal asset. What happened, as I explained you before, in the limited liability, you have you are eligible only till the limit. But if unlimited liability, if you are running a business and if you are in a financial trouble, the creditor can claim your personal assets also. So this is most of the companies adopt for the limited liability. As we draft the memorandum of association, we carefully determine the liability structure based on your model, future plans, and risk tolerance. Our goal is simple: to protect the investor and the company future. Friends, understanding the limited liability is not just a legal compliance. It is about making an informed choice that define your financial security and business sustainability. Now we have covered the liability portion. The next clause which comes in our memorandum is an capital clause. I must say that the capital clause is the backbone of the company. Without the capital plays a very, very, very crucial role in the incorporation of the company. Every company, whether it is an small or large, stand on a foundation of capital, the financial background that fuel its operation, expansion, and long-term sustainability. A memorandum of association, the capital clause, plays a crucial role in defining its foundation. The capital clause defines the company authorized capital, the maximum amount of capital that the company is permitted to raise by issuing the shares. Is also detail how this capital is divided into shares of a fixed value. This clause set the financial boundaries of the company and provide clarity to the shareholders, investors, and the regulatory authorities. Now, why the capital clause is important? Let me tell you why. Because it defines the financial strength of the company. A well-structured capital clause ensure that the company has a sufficient authorized capital or support its growth without frequent alteration. Investor confident, it bring the confidence to the investor, and there is a transparency of financial capacity. Regulatory compliances. The company cannot issue the shares beyond its limit of an authorized capital. When the authorized capital is only through the legal formalities through the MCA. So there is a regularity or a legal process involved in the capital clause. Flexibility. Clause allow business to plan their financial expansion, ensuring they can raise the capital whenever needed. What I have said you, like flexibility for future growth. As your business grow, you want the more capital, you can increase the capital. You can start up with the 1 lakh, then you can increase however you want as per your business growth. What are the key components of the capital clause? The key components are capital. Let me explain what is an authorized share capital. The maximum capital the company can raise divided into shares. The type of shares. There are different types of shares like equity shares, preference shares. Face value of shares. Face value specify the nominal value of each shares. Increase in capital. The company can later, as discussed before also, the company can later amend the capital clause to increase its authorized capital according to the business need, according to the business growth. If you just imagine a company with a bright vision, you have a planning that will incorporate a company, and our plan is such and such, in this way we'll run the company, but you have no financial securities or no financial structure. Without a properly drafted capital clause, the company might faces the hurdles in raising the fund, attracting the investor, or expanding its operations. That's why This capital clause is crafted is very well crafted and ensure the company has an ample capital capacity while maintaining the compliance with the corporate laws. When we fill the I must say, when we fill the capital clause, it is not just a number we are filling, that the capital clause or the authorized capital of a company is 1 lakh rupees or face value of rupees 10. No, it is a financial blueprint that support your business today and that will give you a fuel in future also. Just give me the answer in yes or no. A company can issue a shares beyond its authorized capital without modifying the memorandum of association. A company can issue shares beyond its authorized capital without modifying the memorandum of association. Yeah, most of us are saying no, no, no. The answer is no. A company cannot issue its shares beyond its limit unless the MOA is amended. MOA, we can amend the MOA as per our capital requirement. We can amend the capital clause of the MOA. Now let's move to the exciting part, that is an subscription clause. Subscription clause, I must say, it is a bringing a company to the life with the subscribers. The subscription clause is a declaration made by the first member, also known as a subscriber to the memorandum, who agree to take up the shares in the company. It established the company foundation by confirming that at least the minimum number of members has been subscribed to the business. Why the subscription clause is important? Let us discuss. The subscription clause is important because it comply the legal requirement. A company cannot be incorporated unless the minimum number of members subscribes to its shares. This is as per the Companies Act. There should be a minimum number of the shares if you go for the incorporation of the company. There are certain criteria is fixed for the different companies, like private company, public company, one person company. If it is a private company, minimum two subscribers should be there. If it is a public company, minimum seven, and if it is a one person company, one subscriber is enough. But you cannot go less than this criteria. Second important aspect is commitment to the business formation. The subscribers show their intent and commitment to start a company. Like if you invest in a company, you will be eager or more motivated to start a company and run your company in a most efficient manner because you have invested your money in that company. Ownership and control. Definitely, if you invest your money in a company, you will be an owner of that company, or you will be have a controlling power of in that company. Non-recoverable agreement. Once you have signed the MOA, you become the subscriber of a MOA. You cannot withdraw your commitment. You are full-fledged with your commitment and with your object to run your company in a most efficient manner. Let me tell you, the subscriber clause contain the name, address, and occupation of an initial subscriber. Each subscriber must have at least one shares. You cannot go with the less shares. You can be a nominee of a company, like if you want, if a company purchases share of another company, the company has an authorized person, but each person has to hold at least one share. This clause must be signed in the presence of witness. This is an first official record of the company in the ownership structure. In the memorandum, whoever the sign the subscriber cause become the owner and the promoter of the company. Think of this clause as a birth certificate of your company. It marks the beginning of your corporate journey where the first shareholder come together to lay a foundation of the business. As a professional, we ensure the subscription clause is drafted accurately, legally, and intentionally, setting the right tone of ownership, compliance, and government. Let's have one exercise. If you are starting a company today, just tell me whatever comes in your mind. If you are starting a company today, how many shares you will subscribe to the company? Just whatever comes in your mind, that I can invest this amount, or I can invest this amount, and just anything. No, nobody's replying. Only yes or no they reply. Okay, I must say, if I will go, definitely I will spend as per my financial strength. Somebody says 75%. Okay, see, I will if the question comes to me, I will spend 75%. Okay, you will have a controlling more than 50% of controlling power in that company. Whoever will spend 75, that's a nice one. But like for me, first I will check my the capital strength and how much controlling I want in a company. That we need to look first before going for the subscription. MOA and AOA. Now let me tell you what are the rules for signing of MOA and who must sign. Who must sign the MOA? Every subscriber of who make an investment in the company or who holds a shares in a company. The minimum number of subscribers, as I have informed you earlier, for the private company it is 2, for the public company it is 7, and for the OPG it is 1. Witness requirement. Each subscriber must sign in the presence of at least one witness. The witness can be a professional such as a chartered accountant, CS, or advocate. As informed you earlier in the subscriber page, what are the detail you require? Your full name, address, occupation, the number of shares you have subscribed, and your mother or father name. Let me ask you one question again in yes or no, because you are replying in yes or no very very smoothly. Can an MOA be signed digitally? You can sign the MOA digitally, or the physical signature is only compulsory. Just reply me yes or no. The MOA can be signed digitally. Okay, yes. Most of us saying yes. One of them say no. Okay, 50-50 is going on. Okay. Yes. The MOA nowadays, what happened in V3 portal, the MOA is signed digitally only. Now, for the incorporation of process in V3, the MOA is required to be signed in digitally. Previously, when the incorporation was done in V2 portal, the subscriber sheet has to be signed physically under the witness of any person. But still in the V3, the subscriber sheet is required to be signed physically. In what are the cases? Let me tell you. As per Rule 13 of the Companies Act, okay, the subscriber who does not belong to a commonwealth, they have to like a foreign national signing MOA in UK, USA, or Canada must sign their document. Not only the subscriber sheet, but their document also, like residential proof. They don't have a pen, they passport. Okay, whatever the address proof or the identity proof they give, plus MO and AOA, they require to be signed physically, and that document should be notarized or apostolized. Depend on the condition of depend on the rules which you can see on the and the proof of identity should be notarized in the part of an commonwealth. The person who is not in part of the commonwealth, or who require the apostolize in accordance with the The person who is not the part of the commonwealth can go for the apostolize. The different countries have different rules where they can do it, but they need to have a physical signature. A person who visited India, please, previous slide. A person who visited in India and intended to incorporate a company, in such case, the incorporation shall be allowed if he or she is having a valid business. It may be possible that the foreign person comes to India and sign here, but in that case, he must be holding a valid business visa. The valid business visa is not applicable to a person in case a person of an Indian origin or the overseas citizen of India. In this case, if he does not hold the business visa and he come to India, he can have a sign. But the other who belongs to the Commonwealth or UK, USA, the documents must be notarized or apostolized in their particular country. Let me tell you the submission of the supporting documents. What are the documents you require to submit? And the director or the subscriber have to submit the self-attested copy of their passport, which is mandatory. Address proof. Address proof can be a bank statement, utility bill, or driving bill. It must ensure that the bank statement or the utility bill should not be older than 2 months. And if he comes to India, then the valid business visa. Next, we comes for the preparation of article of association. After finalizing the memorandum of association, the next step comes as in preparation of article of association. While I can say that MOA defined the company fundamentals, but AOA serve as internal rule book governing the company's the AOA mention your the rules through the rules how you can proceed further. This an article of lays down that the rules and regulation for managing its affairs, the right, duties, and power of shareholders, directors, and the internal governor structure of a company. There are some certain contents in the article of association. What are the topics are covered or what are the headings comes under the article of association? The share capital and the variation of right, which contain the rules for issuing the shares, transferring of shares, altering of shares capitals, call on share, process for making the call on unpaid shares, transfer and transmission of shares, like how you can transfer the shares or the transmission of shares. Such rules are mentioned in the article of association. Voting rights and meeting for future of shares. And the the article of association also explained the procedure for conducting the board meeting and the shareholder meeting. The dividend and reserve, winding up of the company, appointment and power of the director, like how the director can be appointed, removed, and the others' powers, distribution of profit and creation. This all is framed in the article of association, but it is framed under the frame of Companies Act 2013. You cannot frame anything like I will keep only one subscriber, or I can transfer the shares whatever the way you like. No, this all things are framed, but it is framed under the Companies Act 2013 rules. Same as like memorandum of association, the article of association also contain the table from F to J. If the companies is limited by shares, they have to adopt a model table F. If a company limited by guarantee without share capital, table G. If a company is limited by guarantee with the share capital, table H. Table I is for unlimited companies without share capital. Table J, they AOA for unlimited companies with the share capitals. Company can also adopt this table or modify as per their specific requirement, but the one thing you have to note that it should be under the guidelines of the Companies Act 2013. Beyond that, you cannot proceed. What are the legal requirements for drafting and filing of AOA? The same as what we discussed in the MOA, it should also be signed by the all subscriber. Each subscriber should be signed under the presence of a witness, and the document must be stamped and filed with the ROC for the incorporation. Friends, while the MOA is a foundation of company, the AOA is a guidebook that ensures smooth functioning and the long-term success. A well-drafted AOA is essential for maintaining corporate discipline and achieving business growth. Once the MOA, AOA, object laws, everything is draft, you must know what are the documents you required. What are the documents you required for the incorporation of the company? First one, declaration by directors and subscribers. This is the mandatory declaration that the subscribers and the director have to give while filing the incorporation, while the incorporation process. This declaration you have to give under form INC 9. Declaration by a professional. Declaration, this comes under form INC 8. This all have this declaration have a particular a fixed format which is given under the Companies Act. Okay, in this format only you can file it. So declaration by a professional. This declaration is given by the company secretary or the chartered accountant or the cost accountant, that they must declare that all the rules under the Companies Act has been compliant for the incorporation. Consent to act as a director, form DIR 12. Here, the director give their consent that they are willing to be a proposed director in the proposed company. Proof of register office. Yes, the proof of register office must provide a valid proof of its register office address. What should be the proof? Ownership proof, which can be a property deed, lease agreement or rental agreement, utility bill, which can be an electricity bill, water bill or telephone bill. No objection certificate if the premises is given on the rent. Okay. One more thing, the utility bill should not be older than the 2 months. Once all these documents are submitted to the ROC, the ROC will approve the name after, approve your incorporation. Here, the another thing is also mandatory, the DSC and the DIN. All the directors should have their DIN and DSC. If the director don't have a DIN, they can while at the time of incorporation of the company, they can apply for the DIN. Now comes to the next step, the payment of fees. After completing the drafting of memorandum, article of association, and all the incorporation documents, next we come with the payment of the prescribed fees. So let me explain you. The fees for the name approval, as I have discussed earlier, is rupees 1000, and if you go for the extension, it will be 2000, 3000, depends on the day for which you want to go for the extension. The stamp duty on MOA and AOA is approximately 1000 to 10 lakh for the MOA and 500 to 5000 for the AOA. Next slide. Basically the filing fees for the incorporation on the authorized capital of the company, as you can see on the screen, if if the authorized capital is up to 1 lakh, it will be 863. If it goes to the 10 lakh contribution, 863, and more than 50 lakh, it will be more than 1 lakh rupees. And the private company with an authorized capital up to 15 lakh are exempted from the ROC fees. I mean, there is a nil fees. The fees for DIN is rupees 500, and the DSC depends on the service provider. They may charge 3000, 5000, whatever, it depends on the service provider who is providing a DSC. The PAN and 10 DSC also come in the spice form as 131 rupees. Now, how you can make the payment? You can make the payment of the form through net banking, debit, credit card, or NEFT, whatever. Once the payment is successful, the SRN is generated. What is the SRN? The SRN is a service request number. This service request number help you to track the status of the company. Once the status is get approved, your company get approved or your company comes into existence, and the ROC gives you a certificate of incorporation. Now, what is a certificate of
Pri-
incorporation?
Priyanka,
Uh,
Priyanka, there's a question in the chat box. Is the fee same
okay.
for LLP as well? Asked by Jim.
Hmm. Sorry, repeat again.
Is the fee same for LLP as well?
No, sir.
This is asked
Fees
in
is
the chat.
different for LLP. Fees is different for LLP. Fees is different for OPC. So, certificate of incorporation. The certificate is a birth certificate of a company which says that the company is come into an legal existence, which is a separate legal entity. The company has become a separate legal entity. Once the certificate is issued, what are the things contained in the certificate of incorporation? Okay, the sin number. The certificate of incorporation contain the sin number which have 21 digit, the name of the company, the date of incorporation on which your company has been approved, the company type, whether it is a private company, public company, or a one person company, a declaration that the company is incorporated under the Companies Act, we challenge. What is the importance of certificate of incorporation? In short, I will explain. The certificate of incorporation have its own identity. It is a proof of existence that required for opening your bank account or entering into any contract. Compliance requirement, whenever after the incorporation you go for the GST or the trade license, your certificate of incorporation is required. For any other contract or the tender you are going, your certificate, you have to submit your certificate of incorporation. That is only a valid proof that your company is in existence. The post incorporation compliances, after your company has been incorporated, you have to conduct the board meeting within 30 days from the date of incorporation, where you have to discuss the certain things like opening of bank account, appointment of auditors, the share certificate, issuance of the share certificate, and many more things are there which you can discuss in the first board meeting. As I said, the appointment of auditor is also required. In the within 30 days, you have to file with the MCA regarding the appointment of statutory auditor. Opening of bank account. Yes, you have to open a bank account with the bank in the name of the company, because all the transaction will be done through the company bank account only. This commencement of business, for this commencement of the business, after the incorporation and your board meeting. 1 minute, there is one question. Post incorporation compliance is also specified in secretarial. I cannot view. Sorry, secretarial standard number. Yes, SS1. Yes, the post, see in SS1, what are the things you can, like, you're conducting a board meeting, you have to give it numbering. Many things are there which is not mandatory to compliance, but it ensure our company to run in a smooth manner. After all this, we want the commencement of business. What is the commencement of business? Under section 10A, every company having a share capital have to file one INC form 20A with the ROC, mentioning that they have opened the bank account, they have transferred their subscription amount to the bank, and the bank statement they have to attach with the commencement of the business. And this form is required to be filed within 180 days from the date of incorporation. Okay, and this commencement of business is applicable to the private limited company, public limited company, and the one person company. It does not apply to the company which is incorporated without share capital. This is not applicable, or to the government company. It is not applicable to the government company also. Then the filing process of commencement of the business, as I told you earlier, you have to attach the bank statement specifying that the share subscription money has been subscribed from all the shareholders, and all the formalities has been done, and you have to file with the digital signature, affix the digital signature of CACS, any professional, and you can file the form INC 20A. Now my question is, if you fail to file the declaration of like form INC 20A within 180 days, as I said you about that the form is required to be filed within 180 days. If you fail to file, what are the consequences for this? It is in the Companies Act says that you have to file within 180 days INC 20A. But if the company is not able to file within 180 days, what are the consequences? Can tell me what are the consequences? Yes, correct. Penalty will be levied. Okay. Penalty is okay. We'll see that 20,000 or 30,000, whatever. But the penalty is there. Okay. So yes, the consequences for the non-compliance is the company has to pay the penalty of rupees 50,000 for every officer in default, rupees 1,000 per day, which can be up to 1 lakh rupees. And the ROC may also strike the name of the company from the registrar. The main the penalty is but the ROC have also right, if the company has not filed INC 20 and is still running its business without the commencement of business, the ROC can strike off the name from its register. And third, without the commencement of business, the company cannot take a loan from any finance institute. There are some technical issues which we face during the company incorporation. There is one question, it has been gone. 1 minute. Yeah, something related to LLP. 1 minute. Please explain the compliance for an LLP post getting the incorporation. Yeah, I will explain once. This is a topic under the incorporation of company. I will in our next webinar or whenever we get a chance, I will explain the post compliances for the LLP also. This is basically under the private companies. Okay. Now, what are the technical issues during the company incorporation? What are the we face? Mostly, sometimes the MCA portal does not work. The DSC is not registered with the MCA. It may be possible that the first name differ with the DIN number of the company, and the MCA does not accept that the DIN number is different. DIN details are different, and DSC details are different, and does not get associated on the MCA. Then the MOA, AOA, sometime it create an for uploading the error. The payment sometime 404, as it is a very common error when we goes for the making the payment. This is the most common problem which most of the client face. PAN and TAN number not received after incorporation. Correct. The physical PAN and TAN in the certificate of incorporation, you can have your PAN number, but most of the client ask that we did not receive the physical PAN number or the TAN number. In such case, you just coordinate with the NSGL with your application number and the certificate of incorporation. They will let you know the status. What are the sequence for uploading the spice form? Okay, the first step is part A for name reservation. I told you before that we have to apply for the name first. Once the name get approved, you can go with the spice part B, which cover all the incorporation details with the attachments. Agile Pro, which cover the GST detail, professional tax detail, bank account opening detail. I must let you know that the Agile Pro, the GST is not mandatory. You can apply the GST after the incorporation of company also. It is not mandatory to apply in Agile Pro form only. EMOA, which as already explained you, what are the things to be mentioned in EMOA. EAOA, INC 9, as I told you, INC 9 declaration is given under this INC 9. URL 1, this you can left it. This is basically if you go for the conversion. Then after INC 9, you have to affix the DSC and submit the form, and then it asks for the payment and you get the COI. This is the basically the whole sequence. I must also say that Spice Part A and Spice Part B, Agile Pro, this all can be done at a one time also, if you are very much confirmed that the name which you are applying to the ROC you will get that name. Otherwise, what happen, we what practice we usually follow, first we go with the spice part A for the approval of the name. Once we get the approve, then we'll proceed with certain documents, not an issue. But if you go together, you file spice part A, spice part B, but you must be sure about the names, because if the CRC reject your name, the whole amount or the whole payment which you made for the incorporation will be goes off. So I must suggest that you must first apply for the name. Once your name is approved, it will be reserved for 20 days, and you will be you will be safe enough that this name is with us, and we can proceed with the further documents. Next slide. Okay, this all the things. There is an INC series also, which I will just share you later on, which are used for helpful in for the incorporation of the companies. Various INC series are there. Okay, so I must tell, by working together, professional providing the expert guidance and client driving their business vision, we create a company not only in compliance but also for a long term success. Let us end with the question. If you have any question, you can ask me. Acha, one question from my side. I have leave one question. If you want to start a company, oh, okay, the whole process is done for the incorporation of company. If you want to start a company, what name will you prefer for your company, and why? Like, there might be some reason, nah, and we will select this name only for our company. Most of the client come us and say, ma'am, we want this name only. I say, no sir, it is not possible, it is already identical or similar, the ROC will not give us. But they say, no ma'am, anyhow you do anything, but we want this name only. This is like a very lucky name for us, and so and so and so. So what, if you want to start a company, what name you will prefer? Yeah, think and give me an answer. Okay, no one is there. Sir, would you like to give any answer? Like whatever comes in your mind?
Depends on what company we are going to launch.
Sorry?
Depends on
Shreyas. Yeah, Lakshya says Shreyas Global Private
US
Limited.
global tech. Exactly.
Correct. Okay, fine. This is the end of the session. If anyone has any question, can ask me.
Those of you who want to watch the recording later, if you missed parts of it, you can do it the
Yeah,
next.
you can ask me the question later on also if any query is there.
So thank you so much, Priyanka, for,
Thank you, sir.
for sparing your time and sharing your information here. We look forward to having all of you again next week, same time. We have different topics coming up. So keep track in the YouTube channel, subscribe to it. And plus, if you're already in our mailing list, you'll be getting the reminders each week. Look forward to seeing you Friday, 4:30 to 5:30 next week. Thank you.
Thank you.
Bharat, anything to add? You have
No, no,
one
then.
of
It was a wonderful session, ma'am.
Thank you, sir.
Thank you. And
yeah. Thank you so much.
uh, yeah, thank you, everyone.
Take care. Have a great weekend. Bye bye.
Yeah.
See you all.
Okay. Thank you. Thank you, sir.